I'd just like to make a brief announcement to let everyone know, and I think this is resonating throughout the venue, but to come to the main stage and to the other conference rooms, as many other panels are now starting again after lunch. Thank you. So I'd like to introduce this panel, which is about victims of war, reparations for war crimes committed. My name is Victoria Kerr, and I am a lawyer and consultant to Redress, an international human rights organization based in London and The Hague, and also the Asser Institute, an international legal research institute also based in The Hague. And I've been working on supporting criminal justice actors in Ukraine towards domestic accountability since 2021, and more recently with Redress on financial accountability towards reparations for survivors in Ukraine. I'd like to just provide a bit of a background to this panel. We all know that vast violations of international law have been reported during Russia's invasion of Ukraine since 2014. Many mechanisms are being mobilized on domestic and international levels to pursue accountability of perpetrators. However, victims cannot wait until the end of the conflict. Urgent action is needed to address the harms victims have suffered and to help them rebuild their lives. This panel brings together experts supporting survivors in Ukraine and working to deliver reparations for through both domestic and international mechanisms. So we will explore why reparations are critical for victims, what is most needed in the short and long term, the routes through which victims can seek reparations, and also how they will be financed. So I want to introduce all the speakers on the panel today. So first of all, we have Elena Apchel, who is a woman of many talents. She is an artist, theater director, performer, curator, playwright, and a member of SEMA Ukraine. SEMA is a global network of victims and survivors to end wartime sexual violence. Since the beginning of Russia's war against Ukraine in 2014, she's been actively helping the army and displaced civilians, and since the beginning of the full-scale invasion, refugees abroad. Clara Sandoval is Director of Programs at the Global Survivors Fund, a multi-stakeholder fund to enable reparations for survivors of conflict-related sexual violence. She's been leading the work of the fund in Ukraine for the setup of urgent interim reparations for survivors of conflict-related sexual violence. Next to Clara, we have Igor Shvetskovsky, who is an international reparations and transitional justice specialist, currently serving as senior advisor on reparations and transitional justice with the Office of the International Organization for Migration in Ukraine. Next to Igor, we have Deborah Rees-Verduzko, who is Executive Director of the Trust Fund for Victims at the International Criminal Court, which aims to give effect to victims' right to reparations, facilitate the implementation of awards made by the ICC against convicted persons, and undertake initiatives for the benefit of victims and their families. Next to Deborah, we have Pavlo Pushkar, who is Head of Division at the Department for Execution of Judgments of the European Court of Human Rights at the Council of Europe. His primary responsibilities involve advice to the Committee of Ministers of the Council of Europe and the Council of Europe member states on the measures needed to implement Strasbourg's court's judgments. He's also engaged in work relating to reparations for Ukraine undertaken by the Council of Europe. We are also joined online by Irina Kirieva, who is legal advisor of the Register of Damage caused by the aggression of the Russian Federation against Ukraine. Before that, she was leading the unit of the Ministry of Justice of Ukraine responsible for the development and implementation of international legal mechanisms for compensation for damage caused as a result of the international armed conflict on the territory of Ukraine. And last but very much not least, we have James Patrick Sexton, who is a junior research at the TMC Asser Institute, a research center for international and European law based in The Hague. His primary research interests are unilateral sanctions, international criminal law, and international humanitarian law, with an overall focus on Russia's invasion of Ukraine. So I'd like to kickstart the panel with a question for you, Elena. Could you please describe the work that you have been doing with the SEMA network and with survivors in Ukraine, and what you believe the short-term and long-term needs of survivors are?
Я буду говорити українською, тому якщо хтось потребує переклад, це час одягти навушники. Я представляю організацію Сема Ukraine. Це організація є частиною глобальної мережі Сема. Ті, хто вціліли після війни, після тортур, полону і зазнали сексуального або гендерно обумовленого насилля. У січні 2019 року 20 жінок об'єдналося для того, щоб підтримувати одна одну, враховуючи цей досвід. Це були жінки, які в різний спосіб і з різною тривалістю досвідчили сексуально обумовленого гендерного насилля, перебували в полоні в перші 5 років війни Росії проти України. Після початку повномасштабного вторгнення діяльність Сема Ukraine розширилася, і наразі це вже більше 50 жінок, які продовжують допомагати одна одній, підтримувати в питаннях психологічного відновлення, юридичних консультацій, інформування. Якщо цей полон був довготривалий, 2, 3, 5 років, інформування про те, що сталося за цей час на території України і в світі загалом, тому що це теж дуже часто про абсолютну ізоляцію інформаційну, окрім іншого. І для нас найважливіше в нашій боротьбі те, щоб сексуальне насильство було окремим доказом геноциду в майбутньому. Ми промуємо концепцію співчуття і стійкості, підтримки одна одної і повернення в повноцінне існування в суспільстві з окремими потребами і статусом жертви, очевидно. І якщо говорити про довгострокові і короткострокові потреби, довгострокові, напевно, коли я буду називати, вони будуть для вас очевидними, і це ті, які ми всі називаємо по колу, які звучать на різного роду конференціях, самітах, які є прописані в різних статутах, але я все одно їх назву, тому що вони для нас важливі. Коли ми перейдемо до короткострокових, то вони будуть більш практичні, ті, які є свідоцтвом того, що кожен окремий випадок є унікальним, і універсалізувати їх не видається таким простим. Довгострокові потреби, очевидно, це незворотність покарання злочинців і притягнення винних до кримінальної матеріальної відповідальності на національному та міжнародному рівнях, набуття статусу жертв війни з окремими потребами і отримання всебічної справедливої сатисфакції. Це супровід в суді або супровіди в судах. Це довгострокова стабільна реабілітаційна програма, яка включає медичний огляд і профілактичні довгострокові заходи. Соціально-економічні довгострокові потреби можуть включати різні етапи повернення до соціального життя від працевлаштування, перенавчання, вирішення житлових проблем, тому що здебільшого йдеться тут про жінок, які є одночасно або внутрішньо переміщеними особами, або біженками, тобто ті, що втратили житло. Це також отримання якихось грантових підтримок для відкриття власної справи. Очевидно, йдеться про отримання репарацій від Російської Федерації відповідно до міжнародного права, але ми всі розуміємо, що на даний момент це найбільша абстракція, а в той же час найважливіше вимагання і бажання. І також я тут би додала отримання так званих символічних репарацій, в тому числі всередині суспільства, будування наративу поваги до людей, які зазнали гендерно обумовленого насилля в полоні, які зазнали тортур, і зміну наративу сприйняття цих людей в різних структурах адміністраційних, в поліції, в судах, для того, щоб ставлення до цих людей і механізми поводження з цими людьми були більш гуманними і налаштованими на збереження їх ментальної стабільності. Чого мушу зазначити, і це теж кожен з нас розуміє, дуже мало на практиці наразі. Очевидно, також для нас важливо документування сексуальних злочинів, збереження індивідуальної колективної пам'яті. І тут можна перейти до цих короткострокових, тобто фіксація свідчень не тільки на рівні поліції, так, і якихось журналістських розслідувань, але і на рівні окремого механізму фіксації в теплому середовищі, так, в середовищі близького глибинного інтерв'ю, розслідувань, які би могли проводити, можливо, групи підтримки психотерапевтичної. Тобто це окремо теж треба розуміти, в який ще додатковий спосіб ми можемо фіксувати ці історії, для того, щоб не ретравматизувати людей з досвідом насилля і тортурувань. Очевидно, що потреби кожної жінки абсолютно різні після того, як вони виходять з полону. Наприклад, ми маємо серед наших учасниць жінок, які були в полоні 4 роки, і очевидно, що їхнє здоров'я абсолютно зруйноване. І ця короткострокова, я би навіть назвала термінова потреба в негайній медичній допомогі, негайному операційному втручанні, негайної допомозі матеріальній, навіть на рівні часами одягу і продуктів харчування, вони не можуть бути забезпечені ще не до кінця сформованими механізмами, тому що такі жінки не можуть стояти в чергах, чекати на правильні документи. Тобто мусять бути термінові реакції. І теж ці реакції з емпатією і турботою, де не перепитувати декілька разів, чого саме вона потребує, тому що вона може не знати в цей момент, чого потребує, або не могти відповісти. Очевидно, після звільнення терміновою потребою є відновлення документів або створення нових документів, тому що дуже часто це люди, які залишаються навіть без паспорту, не говорячи там про всі інші документи, там, відновлення дипломів, відновлення якихось справок, посвідчень і так далі. І, на жаль, державою такі механізми реактивного реагування не напрацьовані, особливо, якщо йдеться про термінове медичне втручання, тобто це тільки частний порядок, або якісь неочевидні медичні втручання, я не знаю, наприклад, там стоматологічне. Про це теж окремо можна розмовляти, якщо людина декілька років перебувала в полоні і її змушували або вживати неякісну воду, то вона могла... У нас є випадок, коли старша людина з 76 років була зґвалтована російським солдатом після того, як він зброєю вибив їй всі зуби. І для нас справою честі є дуже терміново допомогти їй просто зробити зубні протези, щоб людина, яка має 76 років, достойно, просто маючи можливість їсти зубами своїми, жила ті декілька років, які їй залишилися. І за кожним разом доводити необхідність тих чи інших потреб термінових є величезним психологічним, емоційним викликом для тих, хто вижив. І, очевидно, ті механізми, які ми вже напрацювали за ці роки існування Semi Ukraine, нам допомагають якби швидше ввести в курс справ наших нових членкинь. І оце якби набування нового досвіду з кожною окремою новою членкинею і є тим механізмом розуміння термінових, короткострокових завдань. Тому мені здається, що одне з найважливіших в майбутньому завдань довгострокових – це теж впровадження людей з досвідом тортурування і сексуального насильства до створення таких механізмів. Тобто, щоб практики були присутні в панелях, в дискусіях, в розробці документів в майбутньому. Це так, трошки довше відповідь, але поки що так.
Thank you. I was just letting the interpretation catch up there. Thank you very much, Elena, for very articulately describing many of the needs that survivors have. Clara, you with Global Survivors Fund have been working very closely actually with survivors of conflict-related sexual violence and towards developing a program of urgent interim reparations for those survivors. Could you describe a little bit the work that you have been doing on that?
Thank you so much, Victoria. Good afternoon, everyone. The Global Survivors Fund signed a Memorandum of Understanding in 2022 with the Office of the Deputy Prime Minister for European Transatlantic Integration, as well as with the Office of the High Commissioner for Gender Equal Policy, Ms. Katerina Levchenko, in order to put in place a program of urgent reparation, and I highlight reparation because this is really reparation for survivors of conflict-related sexual violence. As part of that Memorandum of Understanding, we agreed to do three things. The first one, help to develop that urgent interim reparation program for survivors. Two, we also agreed to provide technical support to ensure that the relevant legal frameworks are developed in Ukraine so that the protection is really there. And third, that we will also work on financing reparation. How do we get innovative forms of reparation to happen, of financing reparation there, so that really we can truly respond to the harms that have been suffered by survivors. In relation to the first one, the urgent interim reparation program, we are currently developing a pilot. Important to say here that this is the first time that during a war, a state immediately responds to say, victims have a right to reparation, we recognize that right, and we need to act on that right. So that's unique about Ukraine, but it's also unique to think about how do we deal with those urgent harms. No, because we need to acknowledge that we are in the middle of a conflict and that we will not be able to deal with all the forms of reparation that are required because there are challenges to that. But we cannot be indifferent to the harms that we were just listening about from Olena that need to be addressed now, in real time. And that is what the urgent interim reparation program aims to do. And we will be following a multi-stakeholder approach where survivors are at the center. They need to be the ones that are given a voice, the ones that are protected, the ones that have to say what they need for what harms, in what forms. And where we will be working with state institutions, with civil society organizations, with experts like Igor from the international, from IOM, etc., in order to make this happen, bringing best practice to Ukraine through this pilot project that will start providing urgent interim reparation primarily through compensation to 500 survivors. The idea is that this pilot will serve to provide the evidence and the learning opportunity for different actors in Ukraine to understand more about how reparation happens. It's beautiful to recognize the right to reparation, but from the theory to the practice, there is a massive challenge to be addressed. And this pilot will allow us to deal with issues of eligibility, issues of how to have in place a survivor-centered approach that does not create more harms for survivors, but that rather really allows them to experience reparation as really transformative, as something that is really allowing them to recognize their dignity. Okay, so this pilot is going to put that evidence there. In the meantime, the legal frameworks are being developed in Ukraine. We wanted to go faster with that, but it has taken time. Every society takes its time to come to terms with what is needed and how to craft the legislation, and Irina will be talking to us in a moment about the International Registry of Damages. Something very peculiar about Ukraine is that there are multiple remedies in place, no? And sometimes clashing. And what we need to do there is not only to develop the legislation, which we are doing, and I'm very happy to say that soon a project of law will be presented in Parliament on this very issue, which hopefully will be approved. But also we need to think about how to ensure complementarity between these various mechanisms, not only for survivors of conflict-related sexual violence, but for all other victims in Ukraine. And finally, we are also working on ensuring that the money to be able to provide reparation to 14 million victims, and the number keeps growing by the day, is there. And for that, we need to think about innovative means of financing. And GSF, together with Redress, but also with our own team and with other relevant stakeholders, is working very hard on that question, because we need to make it happen. And let me just conclude by saying, reconstruction is very important, but you cannot have reconstruction without having a human approach to what is happening in Ukraine, to the destruction of the social fabric, of the social texture that is affecting 25% of the Ukrainian population. So any reconstruction approach has to have a human lens. Thank you, Victoria.
Thank you very much, Clara. And I think a lot of the work that you're doing is also paving the way towards a comprehensive approach to reparations on the domestic level. And I know, Igor, you have been working closely on that, also on consultations with survivors as well, to include them in the process. Could you describe a little bit about the work that you've been doing?
Well, thank you very much, Victoria, for first Redress for organizing this, as well as the World for Ukraine Summit, for making a room for the issue of reparations. It's an extremely important issue, and I am glad to see that the seats are filling up after lunch. So that's good. I'm happy to see that. I was already introduced. I have been working for IOM for the past 20 years, and mostly on issues of reparations and transitional justice and housing, land and property restitution in post-conflict situations. And the reason why we are engaged in Ukraine is it's double. It's because we have done this in so many different countries so far, and we have also worked on international mechanisms for compensation, such as the German Forced Labor Compensation Program and the Holocaust Victim Assets Programs. And as I mentioned, we have worked also in countries like Colombia, Sierra Leone, Sri Lanka, Nepal, and so on. So we have already mentioned, the colleagues have already mentioned, the plight of the victims and the immediate needs of the victims, and also the long-term needs of the victims. What's very specific for Ukraine, and I think that is also the reason why the issue of reparations requires so much attention, is the sheer number. That's something that makes Ukraine very unique. Very few countries you would hear that they have so many victims, and also the diversity of the violations that have been committed. I think, the Russian Federation has gone by the list of the ICC crimes, and they have tried to commit all of them and invent even some new ones. So unfortunately, that's happening, and there is a huge volume and huge diversity of violation, and therefore huge volume and huge diversity of victims there which are in need of reparations. And reparations are very important for the victims. It's not only about having seeing the justice in terms of seeing the perpetrator sitting in the court. Sometimes that takes years. Sometimes it never happens because the perpetrators are not identified, and they're not prosecuted, they're not investigated, and so on. So it's about reparations. The purpose of reparations, in principle, is to help the survivor, the victim, to integrate back into the society and restitute to the extent possible, the person to the situation that she or him was before the violation occurred. So how is this done, you know? And Clara already mentioned the survivor-centric approach, and I think that is very important, and that's our focus in Ukraine at the moment, you know. One of the first items that we have on the agenda, working together with the government and with the civil society and with the international partners as well, on this issue, including the Global Survivors Fund and including the International Register, hopefully the International Criminal Court as well, is to create a victim-centric approach which will be based on engagement with the victims and survivors of various types of violations. So not only victims of sexual violence, but others as well. And for this reason, as Victoria asked me to talk about, and I will finish quickly and I'm looking for questions later, for this reason, we will initially focus, and we are already focusing on organizing a consultative process, which is not owned by the international community, but is owned by the Ukrainian government, civil society, and victims themselves. In order to design a proper reparation process, be that national, domestic, comprehensive reparation framework, which covers all types of reparations and includes all the victim categories, or be that an international mechanism such as the one which is in the making in the Hague at the moment, the International Register, there is a need to ask the survivors and the victims not only what they need, but also how do they need it, when do they need it, and engage them in the process of the design of the legislation and in design of the processes and mechanisms which should be put in place. So we will continue working on the file. There is much more that I would like to say about reparation and why it's important to have the victim-centric approach and why it's important to be comprehensive, include everyone, and include all types of damages and all types of remedies. But I will stop here because we have a strict limit of 3 minutes, which I hope I didn't break. Thank you.
Thank you very much, Igor. And I think you've provided a great bridge now to Irina, and I want to turn to you next, Irina. You've been working very closely on the Register of Damages in The Hague, and I wondered if you could share with us some developments on what you've been working on.
Good afternoon, dear friends, colleagues. I'm grateful for organizing for this workshop and for inviting me. And thank you to everyone who supports Ukraine in finding answers to this difficult issue, like pain, reparation, whom suffered from the war. For me, it's quite difficult to speak after the live testimonies and raise formal legal issue, but without them, we will not able to solve the real problem. And first of all, I would like just to make a small disclaimer that yes, money and compensation, it's not only one what survivors are need, but from the point of view of compensation from the aggressor, we are talking about conditional monetization of damages and talking about compensation on aggressor account, not from source of non-governmental organization or AIDS project. So I just try to predict some question about why so long and why, and would like to say that compensation from aggressor account, it's not abstraction. Yes, it's quite a long process because we are, as we understand, it's international process, but we are ongoing in. Given the scale and gravity of these harms what Russia made in territory of Ukraine, critical need to documenting and assessing the extent of destruction, as well as fixing the victim's claim to obtain reparation. So why United Nations in the General Assembly strongly recommended to the member states to create an international register of damage. And such register now has been established by the enlarged partial agreement of the Council of Europe. The register will have its seat in The Hague with satellite office in Ukraine. The register actually, it's not only database about claims and not document evidences the caused harms. It's also like a platform for intergovernmental cooperation between states. As according to the statute, the register of damage serves as a record of all eligible claims for compensation, damage, loss, and injury caused by Russian aggression in Ukraine, and as well as evidence underlying such claim. The register will operate a secure online platform to receive claims from individuals, businesses, and states, including their municipal entities in Ukraine, about damage, loss to injury, a lot of categories. It's a comprehensive list of categories that they have suffered because of the Russian Federation war of aggression in Ukraine. Also, the register will verify that the claims are eligible for including to this register, and it will be in preparation of these claims and of this document for future compensation commission, or like we say, claims commission. So, no adjudicated function for register are predicted. Now, in order to facilitate this process, the register will develop a set of rules and procedures, including a list of categories of damage, which, as I mentioned, to be comprehensive, claims form, evidentiary rules for each category, and other necessary information. Now we're in a process of recruiting staff and setting up its bodies, function, and facilities, including IT platform, because we just pay to attention for previous experience of other UN Commission or previous analogic bodies, and we try to avoid paper documents at all, because, as we mentioned, it's a lot of suffering, damages, and we predict a lot of waiting for a lot of claims to be registered in this register of damage. For today, our main goal is to begin its main operation. It's taken to claims. Maybe in the first, not maybe, we plan the first quarter of 2024. Due to the fact that we are talking about significant scope of work on the development of rules and software, the register will become taking claims for some of categories. We start from some of categories damages, and after gradually expanding its functionality step by step. So we will not be waiting when we try to implement all kinds of categories. We try to step by step that all kind of individuals, businesses, and state entities can start with their claims. Actually, a couple of words about victim-centered approach. All this recommendation, we pay attention to all this recommendation, what we heard from civil society, from NGOs, what will sounds on previous our meetings, and of course, one of the main aims for the victims is restoration of justice, which cannot be had without reparation payment, to real payment, to take a real payment. Therefore, that compensation mechanism is based on the concept that compensation will be carried out comprehensively, covering the wide range of categories of damages and compensations, and actually will be transferred directly to the victim. So we don't create any other bodies. Every who apply to compensation for damages and losses can take this money, can take this reparation directly. Also, we assume that submission of application to the register will be carried out in an accessible manner using electronic tools. For example, senior people or those who cannot use electronic device, we will be provided a separate mechanism for submission applications to do this reparation accessible. The rules also are designed with view that submission of evidence will be accessible. For example, now we made a big project for assessment of a state-national register to avoid to double information, to avoid all information what we can take automatically. We can do this without any extra disturbing of climates. It's also part of victim-centered approach. And the least thing here, we heard a lot of time that civil society should be involved in process of creation, rules for register of damages. And now we make a rounds of consultation with experts and colleagues from Council of Europe. We work closely to create these rules, to create this category, indicate these categories of damages. And after, when these rules will be making one draft, after approving is by board, it's our register. Of course, we will involve all interesting parts, all representative of civil society also will be involved. Our register, it's not main goal. Main goal is a comprehensive compensation system, and our work is ongoing. Thank you.
Thank you very much, Irina, and I think we'll return to some questions a bit later on. But for now, I will turn to Deborah, who's here from the Trust Fund for Victims for the ICC. Deborah, the arrest warrants that were issued were a key moment in terms of accountability for Ukraine. But the Trust Fund for Victims can play an important role in the delivery of reparations to survivors. Can you describe a little bit about the work of the Trust Fund for Victims in the context of Ukraine?
Thank you so much, and thank you for all of you who are present here. I will take a bit of a step back to talk about where the notion of reparations and the international criminal, in the context of the International Criminal Court, comes from. Traditionally, historically, crimes have been committed against each other. The oldest international crime is the crime of slavery and transatlantic slavery. And since then, nations were thinking, how can we make sure that this doesn't happen to humans? And they try to create rules. What is a crime? What is an international crime? And how to create this catalog. So war is terrible, but within war, there are also most heinous things, and those are categorized as serious breaches, which then also carry additional consequences. So throughout centuries, the world has been trying to think of what do we define exactly as an international crime. And the tribunals after the Second World War, the Nuremberg and the Tokyo Tribunal, were able to codify the notions of crimes against humanity, and then also to incorporate what international humanitarian law or the law of war called the war crimes. So what happens within combatants in the context of an armed conflict. At the same time, more or less, the Genocide Convention was adopted to define this other crime called the crime of genocide. And these crimes, and also very importantly at the military tribunal of Nuremberg, the notion of crimes against peace, which then evolved into what we know now as the crime of aggression, is what came into being. So we first had to define what is it that we call crimes, and then we had to define what are the consequences of this. And that was the next era. And that means that even if you are a government official or if you are doing an act on behalf of a state, you as an individual, when you commit these crimes, you are responsible. And the 4 crimes that entail individual responsibility at the international level are genocide, crimes against humanity, war crimes, and the crime of aggression. And that also means that at the national level, courts have to prosecute these crimes. But of course, there are many barriers. Immunity, the time when they were committed, is the person present. And all this is an evolution in international criminal law that keeps going, and we are trying to refine with the purpose of preventing these crimes from happening. Now, the next step that came was to say, it shouldn't be a crime for a specific situation or for one specific country. There were tribunals for the former Yugoslavia, conflict for Rwanda, but there has to be an international humanity notion to be able to do things in an impartial and fair manner. So nations around the world gathered, including Ukraine, and they adopted the Rome Statute for the International Criminal Court. That to date has been ratified by 123 countries who are parties to this. And it established two institutions. The International Criminal Court, that is supposed to help states who are unwilling or unable to prosecute these crimes as a delegation from the international community. But it also said it's not only individual responsibility trials can bring a lot to victims, can bring truth, can bring recognition, and can certainly bring responsibility or accountability to those perpetrators to know what happened, why it happened, and also to ensure that this doesn't happen again. But victims also are entitled to reparations. That is, the harm that was done to them need to be repaired somehow. And the framework for reparations was adopted subsequently to the adoption of the establishment of the International Criminal Court, and reparations can be given in different forms: compensation, restitution, rehabilitation, recognition, or guaranteeing that it doesn't happen again to the victims or to their communities or to their countries. So with this notion, the International Criminal Court has that responsibility of investigate and persecute crimes, and Ukraine considered since 2014 that the International Criminal Court could be an important instrument, and the government declared that even if they were not party, they wanted the International Criminal Court to investigate in the territory of Ukraine for the acts since 2014. And later on, the international community also, with invasion in 2020, said, we want as an international community to bring justice to Ukraine and to deter more crimes from happening. And this is why we have also the arrest warrants of the prosecutor. So while there are investigations undergoing, we as a trust fund have two mandates. The first one is to mobilize acknowledgement of what is happening to victims. The victims of enslavement, deportation, sexual violence, torture, or specific crimes that are linked to what the Rome Statute says. And also, in addition to mobilizing that plight for the victims and acknowledgement, to initiate and define what are the mechanisms to redress the harm that have suffered. Just like the Global Survivors Fund does it for victims of sexual gender violence, we do it on behalf of the international community that fall under the jurisdiction of the ICC. So until the investigations advance, this is our work, and we have an intention to work with all the partners, with the Ukrainian government and those who are engaged in ensuring that victims of serious international crimes receive reparations. Now, if the arrest warrants are enforced and the individuals under the arrest warrants are persecuted and it's determined that they are responsible for the crimes that the International Criminal Court have found them to be responsible, then the judges will order reparations that they, as convicted persons, will need to pay. And therefore, as a trust fund, it will also be our responsibility to advise the judges into what are the measures that can be taken so that those individuals can repair the harm of those victims. So that is our role, and we hope to learn, to listen to what are the initiatives, and to be able to contribute on behalf of the international community that is involved and that is believing and that wants to uphold the rule of law in Ukraine, what can we do for the victims? Thank you.
Thank you very much, Deborah. I'll now turn to Pavlo Pushkar. I mean, despite Russia's expulsion from the Council of Europe, the European Court of Human Rights nevertheless remains an avenue that victims and states, including Ukraine, can apply to in relation to violations committed by Russia prior to the 16th of September 2022. And the court can issue awards of compensation, or in other words, just satisfaction. It also remains competent to hear cases against Ukraine within the limits of its jurisdiction. So would you agree with that? Is it still an avenue which can be open? And what are the challenges in the execution of awards of just satisfaction?
Дуже дякую, пані Вікторія. Я, з вашого дозволу, перейду на українську мову, тому що я побачив, що в залі знаходиться біля 9 людей, які слухають англійську, і більшість представлених тут осіб розмовляє українською. Тому я, з вашого дозволу, перейду на мову Котляревського і Енеїди. Що хочу сказати? По-перше, хочу привітати всіх учасників від імені Ради Європи. Рада Європи – один з організаторів цього форуму. Цей форум проходить під патронажем Ради Європи. І, відповідно, хочу подякувати не тільки форуму, але й нашим колегам з організації «Redress», яка організувала цей захід, і подякувати всім учасникам за участь у цій дискусії з питань репарацій. Щоб відповісти на запитання Вікторії, напевно, треба сказати, що, власне, Рада Європи залишається єдиною організацією міждержавного співробітництва, яка дуже швидко прийняла рішення про виключення Російської Федерації з числа членів Ради Європи. Буквально вже 16 березня 2022 року було прийнято рішення про виключення Росії з числа членів на підставі порушення статуту Ради Європи. І це призвело, відповідно, до припинення участі Російської Федерації у Європейській конвенції з прав людини і, відповідно, припиненні, так би мовити, юрисдикції Європейського суду з прав людини по відношенню до Російської Федерації. Однак, незважаючи на це, можна сказати про те, що дуже чітка позиція і Комітету міністрів Ради Європи як статутного органу, так і інших органів Ради Європи, яка говорить про те, що ті рішення, які були вже прийняті стосовно Російської Федерації, або які будуть прийняті в межах цього юрисдикційного ліміту, який стосується 16 вересня 2022 року, вони будуть підлягати виконанню, і вони вже зараз підлягають виконанню. Наразі, якщо говорити про стан виконання рішень Європейського суду з прав людини стосовно Російської Федерації, то Комітет міністрів Ради Європи має на своєму розгляді приблизно 2400 рішень Європейського суду з прав людини, які стосуються Росії, з загальною сумою відшкодування більше 2 мільярдів євро, які Російська Федерація винна по рішеннях Європейського суду, включаючи рішення у справі ЮКОС. Тому чи залишається цей шлях звернення до Європейського суду з прав людини важливим шляхом? Мені здається, однозначно залишається, тому що такі рішення залишаються важливими з точки зору вимог міжнародного права, і Російська Федерація матиме це рішення виконувати безумовно. Що робить Комітет міністрів Ради Європи як статутний орган, який відповідає за нагляд за виконання такими рішеннями? Комітет міністрів Ради Європи розглядає і на минулому засіданні, буквально минулого тижня, Комітет міністрів прийняв такий документ, як стратегію розгляду справ стосовно Російської Федерації з метою забезпечення виконання. І розглядається два можливих напрямки подальшого нагляду за виконанням. Це напрямок, зокрема, співпраці з Організацією Об'єднаних Націй і напрямок співпраці з громадянським суспільством і недержавними організаціями. Дуже важливий момент, і я завтра якраз буду проводити такий сайд-івент, який буде стосуватися додатково участі громадських організацій і недержавних організацій в нагляді за виконанням рішень Європейського суду. Тому запрошую вас завтра теж приєднатися до цієї дискусії, яка може бути теж цікавою. І завершуючи, що хотів би сказати. Насамперед, ми говоримо про репарації в контексті легітимності тієї системи, яка буде створена. На чому має ґрунтуватися така легітимність і базуватися сама система репарацій? Однозначно на принципах верховенства права. Ці принципи верховенства права і забезпечення захисту прав людини викладені в Європейській конвенції з прав людини. Тому будь-яка система репарацій, яка буде існувати на національному рівні, вона матиме відповідати цим важливим принципам, оскільки будь-яка людина, яка не отримує належних репарацій з точки зору практики Європейського суду з прав людини, зможе звернутися до Європейського суду з прав людини і отримати негативне рішення для України і позитивне рішення для себе з точки зору вимог Європейської конвенції з прав людини. І про це говорить не тільки сама система Європейської конвенції з прав людини, але і нещодавна політична декларація міністрів юстиції країн-членів Ради Європи, прийнята 11 вересня в Ризі, підкреслює основні принципи, які стосуються як національної системи репарацій, так і міжнародної системи репарацій, включаючи її реєстри. Це, по-перше, принцип віктимоцентричного підходу до репарацій, який включає в себе також і консультації з потерпілими, консультації з організаціями, які представляють потерпілих. По-друге, це принцип того, що має існувати належна координація на національному рівні і, відповідно, національна когерентна стратегія репарацій, яка має бути створена на національному рівні. Рада Європи зараз займається цими питаннями, про це вже казала пані Ірина Кірєєва, і завершує таке картографічне дослідження всіх ініціатив стосовно репарацій, на їх відповідність, в тому числі стандартам Ради Європи і, зокрема, практиці Європейського суду з прав людини. Тому що один, зокрема, з прикладів, про які можна говорити, це приклад такої сумнозвісної проблеми в національній правовій системі України. Це проблематика справи Іванов-Бурмич проти України, невиконання судових рішень системне. Ми не хочемо, відповідно, щоб з точки зору розробки нової системи репарацій накопичувалися нові проблеми, які пов'язані з цією проблемою невиконання судових рішень, які, зокрема, стосуються соціальних виплат і виплат, які стосуються осіб, що постраждалих від війни. Дякую.
Thank you very much, Pavlo. And I'd like to now turn to James. So James, we've just touched upon various mechanisms here to deliver reparations to victims in Ukraine, but a key question remains, how will they be financed? There's a great willingness on the part of the international community to finance the reparations and some creative thinking surrounding this. Could you describe some of the thinking and what some of the challenges are?
Yes, thank you, Victoria. And I think for me, this is the most important question. How can we finance these crucial reparations programs in Ukraine while respecting international law? So to put things into perspective, the most recent World Bank report estimates the damage in Ukraine to be worth at least $411 billion. And importantly, this does not include a figure relating to the reparations to victims. So we're really talking about huge figures here. So I will briefly mention the main suggested funding avenues and some of the relevant international legal considerations. So firstly, there is the proposal to confiscate the almost $300 billion worth of Russian Federation central bank assets that have been frozen by sanctions. So perhaps obviously this is where a lot of the attention is at the moment, although there are significant legal and policy considerations. So some argue that Russia's sovereign immunity prevents this measure, while others argue that confiscating assets through executive action is legal and can be justified as a countermeasure to Russia's war of aggression. But I must say that this option is still heavily contested. Secondly, there is a similar proposal to confiscate the assets of sanctioned individuals and entities, and these individuals are sometimes referred to as oligarchs. So here there are slightly different legal issues, namely relating to the human right to property. So there is an exception here if these individuals have been prosecuted for violating sanctions. So for example, the US recently transferred $5.4 million to Ukraine, which was possible because the individual his assets were confiscated following prosecution for violating sanctions. So I personally think that this is a legal and effective approach, but of course the amounts we're talking about are not going to be sufficient. Thirdly, there is this recent question of using the interest from frozen assets to send to Ukraine. So for example, Russian Federation central bank assets frozen in the EU have earned up to 3 billion euros worth of interest since the full-scale invasion last year. So the debate regarding sovereign immunity also applies to this suggestion. However, Belgium has taken a kind of interesting approach recently by taxing this interest and sending some of this to Ukraine. So I think to date around 100 million euros have been sent by Belgium to Ukraine. The EU Commission is also considering this option, also the question of a windfall tax, although the European Central Bank has some reservations, so it remains to be seen whether this will materialize. And if states choose not to follow any of these options, voluntary donations can of course be made to fund some of the crucial interim measures that have been mentioned on the panel today. But I should emphasize that this would be a temporary measure until the Russian Federation pays. It's quite clear under international law that the Russian Federation and the perpetrators of international crimes are responsible for reparations. I think we need to look into the future. We need to remember that this is going to be a long-term process. We don't know what's going to happen. Indeed, if the Russian Federation is to lose the war, and I very much hope that it does, you know, a peace settlement will likely include the requirement for the Russian Federation to pay for some, if not all, of the reparations. So, yeah, those are the main suggestions at the moment.
Fantastic. Thank you very much, James. So I'd now like to ask some questions to all of you as panelists. And the first one really is, we've heard a lot of different mechanisms here, both on the domestic and international levels, but each of these have a different scope and different aims and different priorities. And one big question I have is, how can we ensure coordination and cooperation between the different mechanisms? I know some of you have touched upon this already, but I wonder if anyone has any immediate thoughts. Yes, Deborah.
Thank you very much. We talked about the importance of stakeholders and the different actors that are here. So when we're speaking about coordination, we need to recognize the interest and the role that each of these actors have to play. So first, there is the victims and the civil society of Ukraine that needs to be united, that needs to be working together, that needs to be empowered, that needs to have the knowledge about how reparations work, what it means to them, to create the discourse, the knowledge, the movement, the support publicly. So that is an important element of cooperation. And other civil society organizations that have the knowledge on how is that done, the network of victims like SEMA, the Global Survivors Funds, can contribute to empower civil society to do that. And donors, international donors, should be supporting Ukrainian civil society to advance the notion, because it's the public, it's the victims themselves who need to call for these reparations. And then we need to work together, those that can do something about that, to listen to them. So entities that can help us access that civil society and access those victims so that we can know what they think and what they want. Then there is certainly the government, and the government can be assisted by numerous other international organizations and donors and governments or entities. And therefore, there needs to be a mechanism at that level so that the government of Ukraine knows what is happening, what they can do, what is the offer, and that between ourselves, we are also coordinated. That includes International Criminal Court, IOM, Council of Europe, and other international organizations that are involved. Now, all these efforts are funded by a very small number of donors. And therefore, donors themselves need to also be coordinated so that they know what are the efforts, and we don't compete against each other to try efforts, and that funds are given to the Ukrainian government to think what can be done. Funds are given to civil society so that they can become active and mobilized. And then international organizations also have the resources to engage when the demands are coming up, and we can assist each other. So for me, that is the point into realizing how we can all help each other, but the different levels and roles that we all play in this.
Great, yeah, and I think it's very important to stress that in terms of the financing also, coordination is necessary, because we need to know where the money is going to go once we confiscate it. So that's an important point to stress there. But you also raised the importance of the involvement of survivors and victims in the coordination process. And do you think that, and Clara, I will turn to you because I know you also have some points to make, but do you think that survivors are aware that there is sufficient information about all these different initiatives and how they can be involved in the process? How can we enhance this as part of a coordinated approach as well? Clara, do you want to take this one, or?
But yeah, going to the first two.
Okay.
So I think we need deep consultations, not a one-off consultation, but a process of consultations that allows survivors, one, to be informed about their rights and about current developments in a timely manner, in an adequate manner in Ukraine. Yes, not that they learned that tomorrow is a law being presented, but they didn't have the opportunity to really comment or learn about that, that we need to really to create an opportunity for them to engage with the process in a regular basis. So consultations are key. But I also think that something that is absolutely crucial is that all of us that are involved in considering the development of different remedies need to come together to start thinking now, not when the systems are there, but now, how each of these systems is going to work and how one is going to enhance one another. No issues of eligibility of survivors. Which survivors? What violations? What kinds of reparations? From when to when? You know, these are massive questions. And I don't see us necessarily tuning on how to respond to that, no? So how can we, you know, when reparation is at stake, what we've learned from international practice is that there is not much money to be put into it, and that efforts most of the time run in a parallel basis without losing completely the ability to maximize their impact. So here we have a unique opportunity because there are many actors that want to do things in Ukraine to support the Ukrainian government, to support the Ukrainian survivors, etc., to unite. But for that, we really need to create like a moment where we all sit together. And let's start talking, like you said earlier, no, Igor? Let's talk about eligibility. What does that mean and for whom? All. How the registry of the International Registry of Damages is going to work vis-a-vis a potential registry in Ukraine. How is that going to be synced? How do we create a space for a survivor-centered approach? That is absolutely crucial to me. And the third element that I think is crucial here is we need to think also not only in terms of the reparation remedies, but also we need to think about the remedies that are assistance. And we need to create complementarity measures between the many assistance efforts that are today happening in Ukraine to articulate them for the best effective delivery of reparation. And again, Ukraine is unique worldwide in giving us an opportunity, a historic opportunity to do that. In many countries, reparation and assistance are not even possible, no? You often go think about Burundi or the Central African Republic. You tend to go there for assistance because there is nothing else. But they also have a right to reparation. And here, what we see is a lot of money coming in and services coming in as assistance, and we need to learn from those services. What is happening there that is done properly? How can we make them more holistic so that when the transition happens to reparation, we can build on that and add, no? Because reparation is not assistance, but they can be complementary to one another.
Thank you, Clara. Elena, did you also have something you wanted to mention there?
Так, я би єдине хотіла додати думку про те, що, знову вертаючись до короткострокових завдань, думку про те, що війна вже триває 9,5 років, і ми не знаємо, чи закінчиться вона через 3, 5, 10 або 20. І це означає, що вцілілі можуть мати досвід неотримання жодного типу підтримки, який має 3, 5, 7-річну відстань вже. Тобто, якщо ми говоримо, наприклад, про вцілілих, які були зґвалтовані, які прийняли рішення народити дітей, їхні діти вже пішли в дитячі садочки, і вони можуть досі не бути достатньо поінформовані, достатньо підтримані організаціями державними, міжнародними чи незалежними. Тому, з однієї сторони, це дуже важливо, що ми зараз дуже багато говоримо про майбутнє уявлення великої системної міжнародної співпраці і роботи, але дуже прошу постійно не забувати про те, що нам треба думати і про короткострокові завдання допомогу, в тому числі зміни розуміння, в який спосіб ми можемо інформувати людей. Ми живемо в країні, в якій люди дуже сильно розчаровані в бюрократії, і здебільшого одна тільки думка, що треба пройти якийсь процес домагання своїх прав, у людей викликає ретравматизаційний жах, і вони приймають рішення цього краще не робити. Плюс стигматизація на рівні взагалі сексуальної освіти, розуміння того, ким є вцілілий після сексуального насилля, в який спосіб, особливо в малих містечках і селах, в який спосіб поліція або соціальні служби реагують на людину, яка звертається про допомогу, все це формує ідею про те, що краще не звернутися, краще не займатися способом пошуку репарації для себе. Тому, коли ми говоримо про механізми міжнародної співпраці, давайте теж думати про механізми внутрішньої співпраці органів соціальної комунікації, органів, які відповідають за медичні послуги, поліції. Тобто ті органи, до яких в першу чергу звертається, якщо звертається, а це в найкращому випадку і в дуже невеликому проценті, якщо звертається вцілілий або вціліла. Тобто в який спосіб вони будуть дізнаватися про своє взагалі право і можливість щось мати в майбутньому, або тут і тепер отримати будь-яку з форм підтримки, це наразі дуже ситуативні процеси. Тобто ситуативно ми десь з кимось в якихось подорожах знайомимося, хтось комусь розповів, хтось комусь довірився. Наразі більшість позитивних, якщо можна взагалі в ці часи використовувати це слово, кейсів, пов'язані з інтуїтивними процесами внутрішньої міжлюдської довіри, аніж з попаданням всередину діючих механізмів в низових структурах адміністративно-медицинської комунікації країни.
Thank you very much, Elena. And I think it's very important that survivors feel empowered and feel aware and that they can contribute and of course, lead these initiatives towards reparations. And I think it's a point for us all to take away on how we can better do that, all of us who are working on reparations. One other point I wanted to touch upon was, of course, we're all aware of Russia's responsibility under international law to make these reparations, as they are responsible to provide these reparations. There is a narrative that kind of underpins a lot of the efforts towards reparations, towards making Russia pay. And I wonder what you all think of this narrative. Do you think that this is a helpful narrative, or do you think that it detracts from a survivor-centered approach? What are your thoughts on this? Anyone want to take this one? Павло.
Я можу спробувати. Надзвичайно складне питання. З точки зору Європейської конвенції з прав людини все-таки можна говорити про існування позитивного зобов'язання забезпечити репарації, створення системи репарацій. Тому що ми говоримо не тільки про відповідальність держави в міжнародному праві, і тут я хочу повернутися до того, на чому має ґрунтуватися співпраця, як на міжнародному рівні, так і на національному. Вона має ґрунтуватися на вимогах міжнародного права. І в першу чергу на статтях відповідальності держав в міжнародному праві, які є частиною, в тому числі, статуту реєстру Ради Європи щодо відшкодування шкоди. Але якщо говорити про практичний аспект забезпечення репарацій, то з точки зору Європейської конвенції з прав людини оцей аспект забезпечення відновлення порушених прав, він в першу чергу, механізм буде лежати на державі. Можливо, це відповідь на те запитання, яке ви поставили, пані Вікторія.
Sorry, I was just letting the interpretation catch up again there. James, I think you also want to make a point.
Yeah, maybe just to pick up on these points. I think from a financing perspective, for financing the reparations, I think, of course, we need to remember that legally and morally, the Russian Federation must pay. But I think that we should not focus on this so much. This is going to be a really long-term process. And I think that we should not let this blind our efforts to seek these interim solutions and also to seek financial solutions that are not the confiscation of Russian central bank assets. You know, these things will perhaps gain smaller amounts, but will help to kind of ensure some sort of reparation in the meantime. So while keeping the Russian Federation must pay in our minds, we must also kind of face the realities and deal with what we're facing at the moment.
Yeah, Clara.
I think that there are different types of responsibility at stake, and by just looking at the responsibility of Russia, we might be omitting or deleting a little bit other types of responsibility that are also there under international law. So one thing is to say Russia has committed a wrongful act, various wrongful acts under international law, and must be liable for that. Fine. Civil liability, that civil liability owed to the Ukrainian state and owed to the victims. Yes. The other one is the criminal responsibility of the perpetrators that have actually committed those crimes. They are also responsible. But there is a third form of responsibility, and it's the responsibility that Ukraine has as a human rights guarantor, given the treaties that it has signed and ratified internationally. And under those treaties, Ukraine is responsible for ensuring access to adequate and effective remedies at the national level. And those remedies are of different types, including access to reparation. And then Ukraine gains the right to repeat against Ukraine. And I think these are key principles of international law that we need to remember. And at times are not that very present. But the other element here related to the survivor-centered approach is the how do we go about delivering on them and the mechanisms that each of them can trigger to access reparation. And on the state-to-state responsibility level, we can be bound to think about the damage in a very quantified manner and prove me, at the international level, show me the evidence, and then I will pay, yes? But that is not the type of justice that many victims will be able to access, and then we lose the survivor-centered approach. How do we ensure to comply with that obligation to have adequate and effective remedies in place, that we put a system in place that is able to respond to the needs of survivors, no? Survivors will go to a domestic reparation program without sometimes not having evidence that I was raped, because simply there were no medical services, there was no one, I cannot even recognize the person who raped me, even though I was raped 10 times, yes? Simply I don't have that evidence. So it would be absolutely wrong to ask me to have to prove with that in a court of law, no? So what you do there is that you create the information to try and back up the claim of the person, and that is an obligation that we all have, no? The many NGOs like Truth Hounds, etc., EU, CCI, etc., putting this background information together, but also the state. I think we have fantastic information in Ukraine today to back up many of these violations and to allow victims to be able to access reparation in a truly, survivor manner, in a way that does not create more harm for them, not only for survivors of conflict-related sexual violence, but also for other victims. So how those mechanisms will work is something that we need to bear in mind when we think about the different forms of responsibility that we have at stake.
Yep, absolutely. One thing I think, Igor, that you mentioned earlier was the efforts towards the reconstruction of Ukraine. And I wonder how you see reparations playing part of these wider efforts towards reconstruction. Are these parallel discussions or are they connected?
Thank you very much. This question actually will allow me to go back and answer some of the other questions. I think, moving forward, it's very important to start working on reconciliation. but I'm not thinking about reconciliation the way that you would think reconciliation between states and between what is going on now between Russia and Ukraine. Reconciliation between different discourses that are being used now, outside of the legal domain and inside the legal domain. So outside of the discussions about the reparations and inside the discussions about reparations. So we hear a lot about, the efforts to reconstruct Ukraine, particularly when in connection with the discussions about the confiscation and repurposing of assets, etc. So one time you can read in the same newspaper that the purpose of the confiscation of the assets is reconstruction. Another time you will read that it's a reparation. A third time it's going to be recovery, etc. I think there is a need, to agree on a common scheme, and that's a very important going forward in terms of financing reparations concerning Ukraine, on a scheme which will be accepted by everyone, on a generic principles about how these funds which will be confiscated or voluntarily contributed in some cases will be distributed, and to whom and why and what would be the methodology. I think now there is no clarity between what is reconstruction and what is reparation, and that these terms are sometimes used interchangeably by politicians. But also if we look, within the discourse of reparations, and that has been already touched upon, I think we have a different views, and Clara and others already elaborated on that, what is the view of the state-to-state reparation, and what is the view of victim-centric reparation, and what is the view of just satisfaction from the point of view of the European Convention, So we need to work a lot on reconciling all those languages. So what does it mean to be a victim of human rights violation and have a right to remedy and reparation under the UN basic principle and guidelines? How that compares, with the Council of Europe decision and the statute of the International Register, how that compares with the work of the ICC and the work of the Trust Fund. So we have a lot of reconciliation work between discourses on reparation and reconstruction, broader issue of reconstruction to do before we move forward, because otherwise we might end up with an arbitrary decisions at different levels in terms of both creating mechanism but also distribution of money. And this could lead to much bigger problems down the road. So there is a lot of work ahead of all of us. And I think in terms of, to answer one of the previous questions, in terms of what is important, yes, coordination is key, but it's not coordination between organizations, it's coordination on the issues. I think we need to look for issues of complementarity, compatibility and interoperability between the different systems, the national, the international register, the ICC Trust Fund, and any other mechanism which might pop up in the future. So I will stop here. Thank you very much for asking this question.
Thank you, Igor, and I think that's absolutely the correct approach, because from there you can then also identify the gaps where there are things missing which we can all address together. I want to open the floor to questions from the audience, but I firstly want to turn to Irina online, because I'm aware that we haven't turned to you, but I just wonder if you have any comments that you would like to make in response to any of these questions.
Yeah, it's really interesting discussion, and a lot of good ideas, and of course it will take attention, and unfortunately I don't see some representatives of Ukrainian government who make a lot of efforts to organize this assistance, to organize this system of compensation, but more than less. Actually, from my side, from side of Register of Damage, it's a really useful tool, because, as I mentioned before, I worked in Ministry of Justice and started this process to create this Register of Damage, to create this compensation mechanism from Ukrainian side. And now it's making it easier to stay in touch with the Ministry of Justice, Ministry of Social Policy, Ministry of Digitalization, connection regarding national registers, and all these consultations, all these discussions are held. It's systematically job, it's not just eventually process. And so this part, I mean, how it's connect Ukrainian system and international system, this work ongoing. This part is closed. What about consultation with victims? Yes, it's really important part, really necessary, but maybe now I just put a maybe big portion of cold water that compensation system was concept of compensation system was as comprehensive, and we have to think about all kind of damages, all kind of sufferings, and all kind of people who suffered from the war. So we can not to pay attention just one category or second one. Of course, we mentioned some prioritize for individuals, of course, and in this time, in this question, we are make a lot of efforts to make this reparation accessible. About information, all our steps, regarding the create of international compensation mechanism, also our society been informed. Of course, it's a difficult question because our people, as we can now, wanted to reparation just now. They wanted some compensation just now, but international law, it's a quite long process. But we try and do a lot of efforts that every who suffered from war just will take two things, reparation and justice, restore justice. They will take money from aggressor, not from other sources. And this is also one, not at all, but one of main part of compensation system, at least.
Thank you, Irina.
And actually, yes, and actually, yeah, we are open to your ideas, to your propositions. All of them will be just looking and assessed, and we not close any process.
Thank you. And yeah, I think it's a great point you make that compensation is key, but it is one part of a broader process, and it's something for all of us to take away and to work on. So in the last minutes we have left, I'd like to open the floor. So I see a few hands up already, so I'll go to this lady here, first of all. I think somebody has a microphone.
Thank you. Association of Reintegration of Crimea. I have several questions for you. The first is, can the ecological problems can be counted? What has happened with Kherson Oblast, with Black Sea, with Crimea area? Can we count it and can we compensate it? Also, we are talking about what are possible forms to compensation the damage caused by Russian naval aggression against Black Sea and Danube shipping for third countries may be pointed, because river shipping has also suffered a lot. Also, the question about mechanisms where to find money, are there possible forms and mechanisms of restrictions on Russian export assets to seizure, in partially to finance urgent Ukrainian needs?
Okay, there's 3 questions there. So does anyone have any immediate responses? Pavlo, first of all.
Just on the environmental damage, I think environmental damage is being considered. It's as one of the potential categories of the domestic claims in the first place. And this is something that we are discussing as a part of this mapping of reparations initiatives in Ukraine as a part of the Council of Europe work. I know that the Office of the Prosecutor General of Ukraine is pursuing this issue of environmental damage very seriously, and they will have some initiatives very soon on this together with the Ministry of Environmental Protection. Now, we can speak later about it with you if you wish, but the whole concept of environmental damage is extremely complex. It differs a lot from damage to individuals and maybe property damage to the communities. You have to have a proper assessment of environmental damage, which differs from the regular forms of assessment that are even accepted in the Ukrainian legal system. So it's a very complex legal work that needs to be taken, and that's something still to be pursued.
Deborah, may you have an answer?
Yeah, from point of
sorry, Irina.
international.
Sorry, Irina. I'm just going to turn to. Oh, okay, Irina, go ahead. Go ahead.
Oh, yeah. From side of International Register of Damage, also I can say that environmental damages also included in scope of damages which will be compensated. Now we're in the process of methodology of there, how it's documentary fixed, how it will be rules for assess it. But this is one of big part of damages. And about second one question about ways to fund the money for compensate. Now we in the process of negotiations, discussion with international legal experts, with representatives of international from our states, with our partners, and we try to find a legal solution for this question, how we can to accumulate funds for compensation and reparation.
Thank you, Irina. Deborah.
Yes, very briefly. In the international criminal law, in the International Criminal Court, the framework is that if an environmental damage ends because of its effects, may end up constituting a crime against humanity or a war crime, but because of the effects that it may have on individuals, not per se. However, there are initiatives at the moment to amend the Rome Statute to propose ecocide as an international crime in itself. So in the International Criminal Court, there are currently avenues. So in respect to the affectation to the environment, it has to have a link to a crime that is already in the Rome Statute, and that's where it comes to how do you build a case about that.
Thank you, Deborah. James, I think you also had an answer.
Yes, just to quickly follow up on your question regarding whether Russian exports can be seized to fund reparations. I think as a general rule, the consensus now would be no, unless they are somehow involved in trying to circumvent sanctions. So large parts of the Russian economy have been sanctioned by the EU and the UK and the US. But one thing that I think is quite interesting, which could apply to companies that have benefited from the war, is this proposed windfall tax. So this would actually apply to companies in the EU, potentially in the UK and the US, basically that have seen their profits increase dramatically because of the war. Not necessarily that they are doing anything illegal, but perhaps like natural gas companies or something like this. The proposal to kind of increase the tax for the companies that have kind of gained through the war, I think that that could be quite an interesting proposal to kind of fill in this gap that there is, because we can't just seize Russian assets as a general rule, if that answers your question. Thank you.
Okay, we're very short on time, but I think we've got time for perhaps one more question. So did anyone else? Vladimir, go ahead.
Я теж говоритиму українською. У мене питання до пані Ірини Кірєєвої. Пані Ірино, я так розумію, що ви представляли з представлених в панелі механізмів той, який є найбільш близьким, доступним для громадян України. Ну, принаймні, мав би бути. Тобто громадяни України, які потерпіли від російської агресії, мали б можливість заявити про ці збитки, бути внесеними в реєстр і отримати, ну, хоча б примарливу таку надію на колись отримати компенсацію. Я хотів, оскільки ви тут єдина людина, яка пов'язана з урядом України, хотів вас, щоб ви прояснили таку ситуацію. От війна у нас ведеться з 2014 року. Там, з 2014 року окупована частина Луганської, Донецької області, Крим цілий. Там проживало понад 4 мільйони громадян, які на цих окупованих територіях. Але в цей реєстр і ці люди страждали, багато з них загинуло, були змушені покинути свою територію за відданість цій державі. У багатьох вбили родичів, багато пройшли через катування, людей гвалтували, позбавляли майна. Ну, тобто весь спектр порушень був. Але в цей реєстр, який уряд створив спільно там з міжнародними іншими організаціями, але з подачі уряду України, ці от 4 там, чи скільки цих мільйонів українців, наших співгромадян, вони не потрапляють. Ось пані Олена, яка сидить разом з вами в панелі, ну, віртуально, вона тут в залі. От вона теж в полоні була в 2014 році. Майно її теж зруйноване і лишилось на окупованих територіях теж з 2014 року. І поясніть мені, будь ласка, і всім іншим, чому уряд позбавив таких людей, от як пані Олена і багато інших тисяч наших співгромадян, чому він позбавив їх можливості навіть заявити свої претензії до Російської Федерації? І ви казали, що от ви відкриті до пропозицій. Чи вважаєте ви особисто справедливим можливість для таких людей заявити про цю шкоду? І чи готові ви ініціювати ці зміни перед урядом, ну, які ви якби теж тут чуть-чуть представляєте? Дякую.
Дякую за запитання.
Я єдине мушу уточнити, я була в полоні у 18-му році, не в 14-му.
Я відповім з дозволу аудиторії українською мовою, оскільки питання задавалося від України, від українською мовою. Ну, перш за все, хочу ще раз наголосити, що на сьогоднішній день я не представляю уряд України. Я є працівником міжнародної організації «Міжнародний реєстр збитків», але в той же час я готова вам прокоментувати вашу ситуацію. І знову-таки наголошу на тому, що особисто, якщо до мене, оскільки це звучало в питанні, я вважаю, що всі ті, хто отримав будь-які втрати, пошкодження в результаті порушення міжнародного права Російською Федерацією, окупація територій, починаючи з 2014 року, вони безумовно заслуговують на компенсацію. А тепер прокоментую основне питання. Якщо ми на сьогоднішній день, якщо взяти, скажімо так, спростити міжнародні норми міжнародного права, то компенсаційний механізм було створено і запропоновано Україною дійсно вже після початку широкомасштабного вторгнення. І зазначений механізм, власне, як і необхідність створення міжнародного реєстру збитків, необхідність створення компенсаційного механізму було підтримано резолюцією Генеральної асамблеї ООН в листопаді 2022 року, якою чітко було визначено необхідність створення такого компенсаційного механізму, а також зобов'язання Росії здійснити таку компенсацію. В свою чергу, ця резолюція побудована на іншій резолюції ООН, яку було прийнято ще відразу в березні після широкомасштабного вторгнення, де визнано, що було вчинено акт агресії. Таким чином, міжнародне співтовариство закликало здійснити компенсацію за акт агресії, за вторгнення на територію України, починаючи з 2022 року. Відповідно, коли починався створення такого механізму, оскільки резолюцією передбачено, що закликаються держави, учасники Організації Об'єднаних Націй в співпраці з Україною, тобто заклик від початку йде до міжнародних країн, створити такий механізм. В перших проєктах, звичайно, що Україна подавала абсолютно інформацію про те, що відшкодовані мають бути збитки, починаючи з 2014 року. Але це не є рішення України, це є рішення міжнародного співтовариства. Так само Міжнародний реєстр збитків, який діє на підставі статуту, саме він визначив такі критерії включення збитків до Міжнародного реєстру збитків. Відповідно, ситуація наступна. В той же час можу вас запевнити, і якщо ми проаналізуємо національні проекти законодавства, якщо ми проаналізуємо ініціативи, то вони включають в себе заходи в тому числі для уряду, я маю на увазі, ініціативи уряду, вони включають в себе заходи для компенсації постраждалим, починаючи з 2014 року. Враховуючи таку ситуацію, ми не забуваємо про тих, хто отримав страждання до початку широкомасштабного вторгнення, хто отримав збитки. Просто, можливо, паралельно з цим ми будемо створювати окремий якийсь трек, чи, можливо, це питання буде вирішуватися ще іншим шляхом. Але на сьогоднішній день міжнародне співтовариство, яке є фактично спільно, тому що ми всі розуміємо, кошти, які заморожені в Російській Федерації, вони знаходяться в іноземних юрисдикціях. І лише іноземні юрисдикції можуть, країни всі разом можуть дозволити їх вилучити. Лише всі разом країни можуть притягнути Росію до відповідальності. Відповідно, такі критерії встановлено міжнародним співтовариством. Дякую.
Thank you, Irina. And I'm very sorry, but we are out of time on the panel, so that is why we will have to close at this stage. But I think the speakers will be around just after, so if anyone has any further questions, then feel free to direct them there. But I want to thank you all very much to all the speakers for joining us. Very interesting discussions, and we have lots to take away. So thank you very much.
Thank you very much. Have a nice day.
Thank you, Irina.